so much for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is Your Lien is Worthless on Tenant Buildouts, and here's why. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board-certified construction lawyer here in Florida, and today we're going to talk about why your lien is completely worthless on tenant build-out work. I'll explain why it's worthless. I'll explain how to deal with it and give you some pro tips at the end to make sure that if you decide to keep doing work on tenant build-outs, you have protected yourself as much as possible. So if you have any questions, you can use the GoToWebinar chat box, which should be on your screen. We'll answer all the questions at the end. Please do not include the names of any people or companies in your questions. All right, so what are we going to go over today? We're going to talk about why your lien on tenant build-out work is completely worthless. We'll talk about the specific reason it is, which is the lease agreement between the landlord and the tenant, and the fact that it probably has what's called a no-lien provision in it. We'll talk about Florida statutes and how it is designed to protect the landlord over you, the lienor. And then we'll go through some very specific steps. I'll show you some specific forms to use on how you can protect yourself. And of course, we'll answer any questions at the end. So why is your lien worthless on tenant build out? The reason that your lien is worthless is because your lien attaches to the interest of the party that contracted with the quote unquote owner. So let me give you an example. If the landlord of the building, so let's assume there's a strip mall, and in that strip mall, the roof needs to be redone. Well, the landlord is going to hire a roofer. Well, the roofer is going to contract with the landlord, therefore that if the landlord doesn't pay the roofer will have a lien on the landlord's property. Let's talk about tenant build-out work. Same strip mall, but now instead of the landlord hiring the roofer, let's assume that one of the tenants is building out a shoe store in that strip mall. The contracting party that's hiring the contractor is the tenant. So generally speaking, the interest of the party that contracts with the contractor is the interest that gets potentially encumbered by a lien. So in my example here, the tenant hired the GC, therefore the GC's lien rights only attach to the tenant's interest in the property. Well, the tenant's interest in the property is a lease. The tenant doesn't own the property, they only own the right to possess it for a certain amount of time. So if the GC isn't paid, their lien attaches only to the leasehold interest. We cannot sell the strip mall. We get to only attach the right to move in and pay rent. We're going to talk about that in a little bit. So one of the ways to figure out, because the first question I normally get is, well, how do I tell who I'm contracting with? Or even worse, if I'm a sub or a supplier, how do I tell who the GC is contracting with? You need to check the public records in the county where the property is located to see who the owner of the property is. And you have to determine, is the party that the GC was hired by, is that the landlord or is that the tenant? Sometimes people rely on the notice of commencement. This is a pro tip, don't rely on the notice of commencement. And the reason why is that if you rely on the notice of commencement, and the notice of commencement in the owner section says who the landlord is, but the contract is actually between the tenant and the GC, the fact that the notice of commencement listed the owner of the property versus the tenant of the property does not automatically give you lien rights. So you have to understand who the contractor, general contractor, has a contract with. So one of the ways that landlords protect themselves is that when they sign a lease with a tenant, they include what's called a no-lien provision in the lease. It's very standard provision. And what it effectively says is, I, landlord, agree with you, tenant, that you can lease my space, but under no circumstances are you allowed to enter into any contracts that will create a lien on my property. Now, if that no-lien provision exists in the lease agreement, then your lien, if you record one, only attaches to the lease, not to the real estate. So if you win your foreclosure action, because you still have a lien, I want to be very clear, just because you contract with the tenant, or you're a sub or a supplier who contracts with a GC who contracts with a tenant, you still have lien rights. The problem is that your lien right is only in the lease, not in the dirt, the actual real estate. So if you foreclose on your lien, which again, you have a lien, if you foreclose on that lien, you get to move in and pay rent and run the shoe store, the ice cream shop, or the commercial, warehouse. Not what you want. You want to be paid at the sale of the property, which may not occur. Usually we find that if a tenant is not paying the contractor for the work, they're probably also not paying rent. So generally speaking, this is the reason you have to be very careful. If you are owed money for construction and the tenant can't pay you, they may not be able to pay their rent, which means that they could be evicted. And if they are evicted, then your lien on the lease goes away completely, because once they're evicted, the lease disappears. So now you have a lien on this lease interest, which has the possibility of evaporating if they don't pay the rent, because the landlord will evict them. Now, the reality is that this is a real risk for work for small tenants, single operations, very small companies, a restaurant, a yogurt shop, a shoe store. That being said, the risk is much less significant if you are doing work for a regional or national tenant. They're not usually going to allow a lien on their lease to prevent them from moving in. So they'll keep paying the rent, they'll resolve the dispute. So keep in mind that depending on who the tenant is going to affect the financial risk associated with doing the build out. So let's take a look at what Florida law says on this issue, because it's very important. Because a landlord not only needs to include that no lien provision in their lease, they also have to follow some other steps. And if they don't, they could subject their property to a lien even by mistake. So if the lease expressly prohibits the lien, that's the no lien provision, and a notice of that no lien prohibition is recorded in the public records in the county where the property is located, then they have now satisfied their conditions. Now, what does this notice have to say? It has to have the name of the lessor, a legal description of the parcel. It has to include the specific no lien provision that's contained in the lease, and a statement that all or a majority of the leases in that strip mall or office building expressly prohibit such liability. Again, so the landlord does two things: signs leases with the no lien provision, and then records a copy of either the lease or a short form lease with this information in the public record to make the world aware that, hey, contractors, just know if you do work here, you will not have lien rights on the real property. You will only have lien rights on the lease interest in between me and my tenant. So what can you do to protect yourself? Step one, before you sign the contract to do work, either as a GC with a tenant or a sub with a GC or a supplier delivering product, you need to check to see who hired the GC. Was it the owner or was it the tenant? you need to search the public records to confirm who the true owner is, so that you can verify that, oh, wait a second, the GC was hired by the, XYZ Corp, but the landlord, the owner of the property, is ABC Corp, so it's not the same. You need to search the public records for the no-lien affidavit. I am here to tell you that almost every single lease is going to include that no-lien provision, and most landlords are sophisticated enough to record a copy of that document. I've been doing this for a very long time. I will tell you, it's rare. We're talking like 1 in 500 times do we run into a situation where a landlord has somehow not included the provision, failed to record the necessary document, exposing them to a lien on their property. So you should assume that with great certainty that if you're doing work on tenant build out, that the landlord has complied with the requirements of the Florida statute to keep their property free and clear of liens. As a subcontractor, here is the real risk. You need to be very careful about signing pay when paid clauses in your contracts with the GC if you're doing tenant build out work. Let me explain why. If the landlord has done what they need to do to protect their property and keep it free and clear of liens by having the no lien provision and recording a copy of that in the public record, and you sign a contract with the GC, a subcontract with the GC that has a pay when paid provision in it, you have significant financial risk. Number one, you don't have a lien on the real estate. You may have a lien on the lease, but we talked about that having a lien on the lease is a very limited value. Two, if the owner or tenant doesn't pay the contractor doesn't have to pay you because they have a pay when paid provision in their contract. So normally the way you mitigate the pay when paid risk is to have lien rights or right against a contractor's payment bond. But you don't have that with tenant build out work because, as I explained, that lien may be worthless. So be very careful about undertaking the business risk of signing pay when paid provisions with GCs doing work, doing tenant build out work. As I said, you still have lien rights, so you still need to comply with all of those lien requirements, like a timely notice to owner and a timely lien. Again, your lien only attaches to the tenant's interest, meaning you can foreclose on the lease and move in and keep paying rent if you win. There is another trick to potentially undercut a landlord's ability to assert the fact that you don't have a lien on their property, and that is sending what's called a demand for a copy of lease prohibiting liens. Now, the law in this is very specific. You have to send this request in writing via certified mail, physically separate from your notice to owner. You cannot send it with the notice to owner. It can't be in the same envelope. It's got to be a physically separate request demanding of the landlord a copy of the lease prohibiting liens. Here is an example of that language. It has a warning at the top, and it is a demand pursuant to Florida Statute 713.10 sub 3 saying, hey, landlord, please send me a copy of the lease and the provision showing that the landlord's property cannot be liened. You have to agree to provide reasonable copy costs for them sending you the lease, and then you're going to sign it and you're going to put it in the mail, certified mail, to the landlord and to the tenant, so the lessor of the property. If they don't respond within 30 days, or they send you false or fraudulent information, their property is subject to being liened because they did not respond to that request. Now, you have to otherwise comply with all of the other sections of 713. So you have to, if you need to send a notice to owner, timely record a lien, have otherwise improved the property. But if you're looking, if you do a lot of tenant build out work and you're looking for a way to maybe create some right to have a lien on the landlord's interest in the property, the actual real estate, then in addition to sending your notice to owners, you should get in the habit of sending this demand for a copy of the lease. Now, we have this form. You can download it for free at thelienzone.com/forms. We have a list of publicly available forms. One of them is a request for copy of a lease. And again, you should add this to your process if you do tenant build out work, so that at the time that you send your notice to owner, you also send this request. And by doing so, you increase the possibility that if you have to lien, you may have a lien on the landlord's interest in the property. It's not guaranteed, but without it, if the landlord's done what they need to do, you almost certainly have no lien rights in the property. With sending this request, and if they fail to properly respond, you're now in the game where you can argue that you have a lien on the real estate. So to recap, your lien is a very limited value when you do tenant build out work. Do your research, check to see who is the contracting party. Is it the landlord or is it the tenant who has the contract with the GC? Make sure that you understand the pay when paid risk associated with signing a contract with the GC if you are a sub or supplier doing tenant build out work, and send a copy of that demand, or send a demand for a copy of the lease such that you're hoping that they don't respond within 30 days, so that if you have to lien, you can argue that you have lien rights in the actual real estate because the landlord failed to respond to your request. The lien law is very complicated. We have a handy desk tool we're happy to send to you. It's called the Lien-O-Matic. If you go to lienomatic.com, we have a short video on how this tool works. You can keep it on your desk. It answers most lien questions with this device. It's completely free. Fill out your address. We'll send you one. You'll get it in about a week. So check it out at lienomatic.com. So with that, Jesse, do we have any questions?
Well, first of all, Alex, thank you. I appreciate all of your time and attention to detail. This is a little confusing and a little, hard to understand sometimes. So I appreciate it. There are a couple of questions that have come through. So I will go ahead and start. And this was kind of going back to what you were just talking about with that demand for the copy. When a demand for a copy of the lease provision is required to be, I'm sorry, I apologize. When is the demand for the copy of the lease provision required to be sent? What is that deadline? You said to send at the same time as the NTO, but in a different envelope.
Yeah, so typically that is when we recommend sending it, which is right at the beginning of the job. It will only create the right to a lien for the amounts after the notice, meaning you can't necessarily do it when you send the lien. You have to do it at the beginning. The purpose of the request is to give you information such that you can decide, oh, wait, this is not good. I thought I was contracting with the tenant or the landlord, and it's the tenant. So the short answer is there's no specific time in the statute when you have to send it, but you should send it as early on in the project as possible.
Okay, wonderful. Another question that came through, it says, if the actual property owner, along with the tenant listed on the NOC, and the owner is the one who signs the NOC, do they hold any liability even if they have that no lien provision recorded? Could then the real property be included on the lien?
So if the landlord has done all of the things the statute requires, the no lien provision in the lease, recorded a copy of it in the public record, if they've done all of those things, the mere fact that their name is on the notice of commencement or that they sign the notice of commencement does not create lien rights for you against the real property and the owner. So that's why looking only at the notice of commencement would be a mistake.
Got it. Okay, wonderful. Thank you so much for that clarification. Another question that came through, it says, what if the project is on publicly owned property, but the space is leased out by a private company, could I put a lien on that tenant's interest, or would they be required to have a bond on that property because it's public land?
So that's a complicated question. There are fair arguments that there may need to be a bond because it technically is public property. However, there is an exception, and that is that a municipal government is able to contract like a private party and lease space. So they own, an area, and they decide that they're going to lease space for maybe concessions as the municipal agency. Your rights, if you contract with the tenant, will again be to only lien the leasehold interest. So much more likely than not, you're only going to be able to lien the leasehold interest, which if the lessor is a municipal agency, actually may have some more value than if it was a kiosk at a mall, which probably if you're not getting paid, the owner is probably not getting paid rent and is going to be evicted. So the short answer is you probably only have lien rights in the lease, but there are some arguments that we could make that the municipal government should have posted a bond, but I don't like those as much as the prior argument.
Okay. Another question that came through, it says, as a GC that does tenant work many times, the NOC only lists the property owner and not the tenant. When subs send their NTOs based off of the misfiled NOC, does that affect their rights because they did not notice the proper entity? I apologize for misspeaking.
Also a very good question. So the answer is it depends. Subcontractors and suppliers are only obligated to send notices based on the information in the notice of commencement. So if the notice of commencement is wrong and a subcontractor relied on it, they will not be penalized for complying with the incorrect information in the notice of commencement. So the short answer is it'll be probably a bit of a mess because the tenant will say, well, I never got those notices, but the subcontractors and suppliers will likely prevail because they complied. They sent the notices where the notice of commencement told them to send the notices.
Okay. All right. And then another question that came through, it says, how do you search for a no-lien affidavit in county public records? I think what they're asking is what type of a document would they be searching under, whether it's an agreement or whatnot.
Right. So I would recommend it's a two-step process. So step one is you're going to find the property in the tax assessor's website. So step one is you're going to go to the tax assessor's website and you're going to type in the address, because that's going to give you the exact legal name of the owner, because sometimes you think you know who the owner is, but it's owned by some single purpose entity with a strange name, right? So the only way you're going to find that is to do a search in the tax assessor's website, type in the address, you find now the proper legal owner of the property. Next, you're going to take that name and you're going to put it in the recording document section of the county. And you're going to do a search by the name of the legal entity, the legal owner of the property. It's going to show you all the documents, mortgages, notices of commencement, agreements, assignments. So then you're going to, what I typically do is I organize them by date. So you can resort that list by date on most websites. And then you're going to look to find the document that maybe references the agreement. But as to Jesse's point, is it an agreement? Is it an affidavit? There's no fixed rule because every clerk does it a little bit differently. So I typically, when I do the searches, I do not limit my searches by the type of document. I just do a search by the name and I look at all of the documents so that I can see what it is, because I have seen clerks list this no-lien affidavit as an affidavit, others as an agreement, others as a notice. So you need to check all of them.
All right, perfect. Thank you. I do think that that is all the questions that have come through. If you think of another question that wasn't addressed, please feel free to reach out and I'll be sure to answer any questions for you. Next slide, please. All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. I can't stress enough how much using a project information sheet or something of the sort will help you and assist you in getting the information right from the get-go when you're first signing on to a contract and a project. You'll be able to figure out who all those different entities are. So please utilize that. And then next slide, if you don't mind, please. All right, if you don't mind, give us a quick review on Google. We really do appreciate it. Any of your feedback, we take it to heart and see how we can better ourselves in whatever materials and topics we're talking about. And then the next slide, please. And with that, that is all we have for you guys today. Thank you so much for everyone who was able to attend. We hope to see you guys at our next webinar or our seminars. Alex, you really are fantastic. I can't stress that enough. You are wonderful. So thank you guys all for joining us. I hope you all have a beautiful and wonderful sunny day.